for the Declaration of Independence, it so resembles a legal complaint it very well might have been the United States versus King George. There were 5 men on the committee for the drafted declaration, but Jefferson largely did it alone. And if he didn't have a form book with him, he no doubt knew the form in his mind. The terms of a legal complaint, generally speaking, open up with a whereas statement. It explains the purpose of the document. Goes through a statement of law that applies to the matter, a statement that describes the conduct of the defendant, a statement that describes the conduct of the plaintiff, conclusion that applies the law to the conduct of the people, and a signature of the plaintiff. That's how it starts out. That's how a lawsuit starts. Declaration of Independence. When in the course of human events, while Jefferson knew that things started with a whereas statement, they were declaring revolution. They were trying to get rid of the king, and generally speaking, when you say whereas, it sounds sort of like a royal decree. So that's why Jefferson didn't start the Declaration of Independence with whereas, because he didn't want it to sound so much like a royal decree. But he talks about the self-evident truths. He goes through the inalienable rights, the purpose of the government, the indications of the need for the consent of the governed. He gives a statement of law. He's got his list of grievances against the king, which is the king's bad conduct. He talks about the conduct of the colonists as the humble petitioners. He paints his clients in a very nice light, which any good lawyer is going to do. He says nice things about them. Then he applies the law to the facts, and the fact is the only end result, independence. And he pulled that out of the form book. So this is what Jefferson did.